What is involved in the arbitration process? The arbitration process is a kind of dispute resolution procedure where an arbitrator listens to a dispute in a private setting and makes a final decision for the parties involved. The arbitrator will typically specialize in the specific dispute area, such as topics related to commercial businesses, topics related to employment matters, or even sports-related issues. The arbitration process does not occur in a courtroom, and there is not an emphasis on the technicalities of the law like there would be in a courtroom proceeding. In addition, arbitration is usually binding, but if the parties decide beforehand to have a non-binding arbitration, then that is allowed. If the parties decide to follow traditional guidelines, the arbitration process will almost feel like a courtroom trial. There will typically be an opening statement from each party first. Then, the party that is making the claim will present her case to the arbitrator. Through the arbitration process, each party will tell the arbitrator what she believes the results of the arbitration will be and why she should be victorious. There can be witnesses and evidence, and the closing statements will finish up the process. As part of the arbitration process, the parties involved in the dispute can set guidelines or parameters before the arbitration hearing occurs. By presetting the guidelines, the parties have a little control over how the hearing will proceed. However, once the hearing begins, it is the arbitrator who has control over the arbitration process and the final outcome. For people who do not want the outcome determined by a third party, negotiation is a better option. Through negotiations, the parties are entirely in control over the process and the outcome. One of the benefits to using arbitration over litigation is that the parties can develop an arbitration process that fits their individual needs when they draft the arbitration clause in the contract between the parties. For example, they can agree to participate in a non-binding arbitration, or they can decide that evidentiary rules that are followed in court apply or do not apply. In addition, they can set parameters on how involved the lawyers will be, or even decide that there will not be any lawyers involved at all. Also, they can set time limits on the arbitration hearing itself. One of the main differences between arbitration and litigation is that the arbitrator has more leniency than a courtroom judge. Specifically, the arbitrator can actively participate in the case by requesting additional evidence or asking about other witnesses. In addition, the arbitrator usually has about a month to decide the outcome of the dispute. The arbitration may give the reasons behind her award, or she may just state the outcome without mentioning how she came to that conclusion.